When I was assembling this panel, I thought it would be interesting to see if I could find someone on the prosecution side, and I discovered that there was no living person on the prosecution side, but I discovered that Lindsay Duvall, who is trust and estates lawyer primarily in Anne Arundel County, had mention on his website of his father's role in the Brady case. And he has been very generous, and I might say very courageous, in coming here to tell us about the context in which prosecutors operated at the time the Brady case was decided.
Thank you. Yes, I'm in the lion's den. That's exactly right. My father was C. Osborne Duvall, and while I don't have a tremendous amount of content to offer you as to his perspective, I think I can give you something. I wasn't there. I didn't live through it. I came to the law late. I wasn't barred until, wasn't admitted to the bar until 1990. So it's all very much secondhand here, but I'll do my best. In the span of cases developing the rules of constitutional criminal procedure, Brady v. Maryland, in the words of my law professor, Judge Dana Levitz, is probably the most important case, as he would bellow, you'll ever study. As Providence would have it, my father was the state's attorney there in Anne Arundel County. Now, at my birth, I was given the middle name of Warren to honor Earl Warren, the chief judge in the Brady case, chief justice in the Brady case, whom my father clearly respected. How ironic it was then, when I was 6 years old, that my namesake declared in Brady that in the Brady decision that my father had acted unconstitutionally. I'm not here to defend my family. It is notable, though, that it was a very different time. It was a very different time. Those of us who practice now would not recognize it, I dare say. There was a new and shifting perception that the rules of evidence and procedure needed expansion to level the playing field between the state and the defendant. But even the Center for Public Integrity now acknowledges that prosecutors C. Osborne Duvall apparently never considered telling Brady's defense lawyer about that confession, nor did Duvall have to do so by law. However, the Warren Court was informing the nation of what the appropriate standards of con crim pro should be and would be. Now, as an aside, you know, Earl Warren was appointed by Eisenhower, and that was the one political appointment that Eisenhower regretted profoundly as a payoff for a political favor. That's my dig back at the... but it was a very different time. Now, I grew up with stories of how my father's plate, being a public official, when he would go to a dinner, the plate would be rocking, and that his big challenge was to get the envelope of money out from under the plate, wrap it in a napkin, and leave it on the table without anyone noticing. This is Anne Arundel County, profoundly Southern in nature at that time. My great-uncle Frank, who I'm told was a great political machine person back in the 30s, he would have an annual watermelon feast. His feast included speechifying. The boards one day went up on top of a manure pile. He hopped up on top of the manure pile. He started his speech by saying, "This is the first time that a Democratic speech has ever been given from a Republican platform." But that was Anne Arundel County in the 50s and 60s. My father's integrity, though, was reputed among the bar, among the bench, and among the family. The story I grew up with as a kid was that if there was a pencil left on the table at the end of a meeting, my father would not pick it up if it wasn't his. So the law was his North Star, integrity was his vessel, and he continued in that demeanor through the Brady v. Maryland event. To give you a sense of the times, I've also heard it from children of the judges before whom my father practiced, the son of Judge Michelson, as a matter of fact, that as a regular practice before the morning docket, the state's attorney would go into chambers ex parte and discuss the likely disposition of the morning's docket. Now that's unheard of today, but that's where we were. Miranda, far from being a ubiquitous term in our culture, was still an unknown individual in America's Southwest. Now, on my father's deathbed, he described to me what he characterized as the most heinous case he ever handled. Now, I was 20 years old, more interested in politics than law, and completely ignorant of the legal principles and case that we're discussing tonight. I don't recall him ever mentioning the title of Brady v. Maryland. However, in describing the case to me, my father demonstrated more emotion about the facts than I'd ever witnessed from him previously. He described the case, apologies to your friend, he described the case as a thug and his dumb accomplice, befriending an innocent worker at the plastics plant out in Odenton. One payday, these two thugs laid in wait for the victims at the victim's little bungalow in Odenton, hit him over the head. Turned out they also strangled him, just to be sure. Killed him, took a small sum of money, and stole his car. Now, I never knew the name of that case. And it wasn't until I'm sitting in law school up at UB, listening to Judge Levitt's describe this, that the case, it all came together for me. Now, wrapping up, by way of explanation, my family's been around and been participating in law and significant actions in the furtherance of individual rights for some time. The first of all that hit the shores in 1650 was a French Huguenot and grew later to be a well-known planter after starting as an indentured servant. Now, at his death, his estate included numerous law books, and he bore the title Esquire. Notably, he threw off the usual practice of primogeniture, where the great majority of assets would go to the oldest in the family. Instead, he treated his dozen kids equally, both men and women, male and female, equally in his estate. That act earned him a footnote in the book Albion's Seed, which traced early European immigration. The author's comment, however, was that ancestor, Marine Duval, his equal treatment of his children condemned them all to middle-class tradesman status rather than at least having one child to anchor the family in the upper class. Another family member, Justice Gabriel Duval, was a friend of Jefferson and appointed by Madison to the Supreme Court, replacing Samuel Chase. Gabriel Duval later penned a lone dissent from the opinion of John Marshall's majority decision in the 1813 case of Queen v. Hepburn, which was argued, by the way, by Francis Scott Key. Justice Duval wrote the only endorsement of Key's advocacy that hearsay evidence should be admissible on the issue of whether the petitioner's ancestor was free and not a slave. Gabriel Duval then held onto his seat, a la William Douglas, the author of the Brady v. Maryland decision, until he was nearly deaf and unable to fully participate in the court's business. Ironically, when his party regained the presidency, the Maryland seat on the court was filled by Roger B. Taney, the author of the Dred Scott decision. So, coming from a family with a 350-plus year history in Maryland and the law, I offer the observation on behalf of my family that taking a principled stand on behalf of individual rights might condemn your progeny to a lower social class, might result in stiff political consequences, even ironic reversals because of politics. In the case of my father's participation in the Brady case, I submit that his actions were not motivated by some black-hearted wickedness, but that it issued from his integrity in operating within the extant practices of constitutional criminal procedure as he endeavored to give a voice to the victim who could no longer speak for himself. Thank you.